Yeah, please, Lordship.
Yes,
Lordship, I'd like to mention item number 18, Lordship.
18.
18, Lordship. Here, Lordship, state learned AG is appearing. So, he has requested if it can be fixed on, Lordship, 15th of June, Lordship. 1-5, Lordship.
I'm for the
Second
petitioner,
consent.
Lordship.
On the prayer of me and Mr. Estafet, the senior counsel, senior combinator, submits that since the matter pertains to challenging the virus of the rules, the learned advocate general be appearing in the matter. Therefore, prays for listing of the matter on 15/06/2026. Is the prayer not being objected to by Mr. D. Lord, the counsel for the petition? Let this matter be listed on 15th of last month.
15 is Monday.
Hmm?
15 is Monday.
Hearing it's in, then make it 60.
It's okay.
60.
16. All right.
16.
Lordship,
Yes.
Lordship, I beg to mention item number 17. With the consent of Order 40, I am appearing behalf of T. Tapak. T. Tapak is due to medical problems, so he could not attend.
On the ground that Mr. T. Tapak,
Yes,
the counsel, is indisposed today. Mr. S. Yuran,
B. Sibo, on behalf.
sorry, learned counsel appearing on his behalf, prays for listing of the matter after 2 weeks.
Lordship, after 1 week.
After 1 week. Prays list the matter after 1 week.
Lordship, on behalf of the Standing Council for the Health, may I beg to mention item number 1. Item number 1, 11, 12.
One by one. One.
One.
Have you taken consent?
Yes, Lordship.
For what?
Lordship, the council is out of session today.
On the ground that Mr. T. Tagum, learned counsel for the learned Standing Council Health Department. And the learned counsel, Mr.
After 3.
Your name, please. Health learned counsel appearing on his praise for listing of the matter after 3 weeks. Praise allowed list after 3 weeks. Item 1, then
11 and 12, Lordship.
11, 1, 12.
Your service is still awaited.
Yes, this is state appeal.
Yes, Lordship.
State appeal.
Yes, Lordship. Service is yet to be completed.
Huh?
Service is yet to be completed.
So we'll see. Let it come its own turn. This is for orders. You be there.
Lordship. Lordship. And 20.
20 is what?
Yes, sir. Line matter, Lordship.
Why 20?
The lead counsel is out of session, Lordship. We are the petitioner here.
Okay, same order. Is item 1.
No.
Mayor, Your Lordship, I beg to mention item number 21.
Item number?
21. I'm appearing on behalf of leading counsel A. Tatak. Due to some personal difficulties, he is currently unavailable. Due to some personal difficulties, he is currently unavailable.
Hey, Tata.
Yes.
But I will not take up in that case. There is a singulars matter where he has to appear.
Yes.
Is he coming?
No.
He'll not be.
Yes, sir.
There is a matter fixed in a single bench.
He won't be coming.
Ah. Okay. No objection.
No objection.
Okay.
No, I'm ready,
Where are
Lordship.
Mr.
J. Yesu?
J. Yesu. Where is this? Your name is there.
No,
Spelling J
Yochung.
Y O
Chung.
Yochung.
Yorchung. Yorchung. Yorchung ấy.
Y O.
Yorchung.
Chung.
Take it.
Yorchung.
Appearing on behalf of Mr. T. Thatak, A. Thatak, and counsel to the appellate. Press for listing of the matter after 4 weeks, after 3 weeks, on the ground that Mr. A. Thatak, the counsel has some, is disposed today. Press the list after 3 weeks. Mr. D. Lloyd London PP for the state is present.
Item number 2.
Yes, sir.
Yeah, Lordship, some affidavits from the police authorities, Lordship. Still, we have everything, Lordship.
They are accepting your this thing,
My lord.
content, sir.
Hmm.
It has to be looked into.
Right.
They have issued an order also. We'll dispose it of what's there.
My lord, yes, my lord, that can be my lord. With but I have the other issue involved is my lord, non-initial criminal
Yes,
proceeding.
police department.
Lordship, we have
The state has filed an affidavit saying, putting your, I mean, everything on you.
Yes, Your Lordship,
That the police is not taking action. They have to take as per the law. That is what they are saying.
we have taken action. Your Lordship, we have actually prepared the affidavit and we have gave it for waiting, Your Lordship. We're still waiting for that. Otherwise, we have, there was.
But what they'll say? They'll say we are initiating, we'll initiate, we'll take action. That's all.
That's why my lord, specific direction is necessary, my lord.
What is specific direction?
Specific, my lord, left about what happened, my lord. But there should be an order, my lord. In case of any such, my lord, any reporting, my lord, the police need to take immediate action, my lord. That category direction is necessary, my lord, in this case. My lord.
Lordship, it may be taken up 2 weeks, Lordship. We'll be putting on record, sir, Lordship, the steps taken by the police authorities, Lordship.
Okay.
Otherwise, it's already ready, Lordship.
Had Mr. L. Learned counsel for the petition and also had Mr. Estafil Learned senior government advocate for the state respondents. Next para MS T. Learned additional public prosecutor appearing on behalf of respondent number.
Your Lordship.
नाम कर देना
With,
all the respondents
4 to
Your Lordship, I'll be represented by the.
all the
all
respondents
the respondents.
not
The
all.
4 to, my lord,
4 to
हम सबके लिए कर ले
4 to
11, my lord, 11. My lord.
submits that affidavit on behalf of the respondents
1 to
whom she is representing has been sent for
पहले आर्गुमेंट में कर लेगा कॉल
for therefore press for listing of the matter after 3 weeks.
No.
3 weeks. Next prayer.
रिमाइंडर दे दो
Considering above, let this matter be
Yeah,
listed
office में
after
बुलाने
3
दो।
weeks. In the mean, the London additional PP to file the required affidavit on or before the next date. Next.
All right.
वो चीज को हमको नहीं बताया ना
Item number 3.
Please, Your Lordships.
Yes.
Lordship, this writ appeal has been filed challenging the order dated 11/11/2025 passed by the learned single judge
For disposal.
for Lordship, maybe for disposal because Lordship steps.
My lord, for disposal, I may not agree because, my lord, in compliance of the London single judge, my lord, for fresh NIT has been already started, my lord. Perhaps it must be in the stage of approval, my lord. Once that is approved, my lord, it will be a new course of
There's
action.
no
my lord.
interim order.
There is no interim order, my lord. That is the problem, my lord. And for that, my lord, I'll be requiring some more time to take instruction, my
In
lord.
that case, and then we can dispose it of if that is the position.
Saying, my lord,
Once you award the award, nothing remains, nothing will remain.
Lordship here, Lordship.
but, sorry.
Sorry,
The last
sorry.
time also, my lord, the others have said, my lord. Now, my lord, for press NIT, my lord, we've already started. Now, only the question whether that has been approved or not. Once approved, my lord, the matter ends, my lord.
Then
So, I'll take-
you don't finalize. We'll fix it for hearing, so.
Your lordship may fix for next week, my lord, so that I can apprise the court, my lord. Because I'll be requiring written instruction, not verbal, my lord.
What about the private respondents? I mean, writ petitioner,
Lordship
Notice
steps
has
have
been
been
served.
taken. They have not, Lordship, appeared.
notice has been served.
Notice has been served.
Yes,
They
Lordship.
have received it.
Lordship, in the month of February, they had
Of
received.
course, they will not be interested
My
because
lord.
for first tender.
Correct, my lord. I cannot
But
say,
one thing, madam,
Lordship.
your BD is also not free from discrepancies.
Lordship, that is, Lordship, I have
Only
to
one-
satisfy that.
That is we find the ground very strange that you have a lesser discrepancy or lesser
Lordship,
deficiency.
yes, Lordship.
How can that be?
But Lordship, here the thing is,
Privacy, we find that the single bench was right.
Lordship, my submission will be the writ petitioner was not eligible at all because on the date of submission of the bid, Lordship.
But your BD is also not free from, I mean, discrepancies.
Yes, Lordship, but their defect is regarding
Yes,
their
it is.
eligibility.
Therefore, do you have?
Ours is a defect
recommend
in
it?
form and which was already taken up before and the tendering authorities had accepted the defect.
No, that
and-
could not have been.
But otherwise,
Once
we,
your tender equally is having a discrepancies or deficiencies, not conformity with the tender condition, how can you be allowed?
the Lordship here is the
The best way how it is to, you also participate, have you not?
Lordship, we have participated, but Lordship, the only difference is that their defects were defect as regard their substantial eligibility, whether
Yours is,
only in form, only ours were not, and they were in form, not substantial. Otherwise, we were eligible.
so far as EMD is concerned,
Lordship.
you have not submitted in your name. It's somebody else.
No, it is by the chairman. It is not a stranger. The chairman of the cooperative society, not by the, not
Why,
any
why don't you
stranger.
why not in the name of this appellant?
Otherwise, Lordship, the earnestness is shown, Lordship. Our sincerity is shown. They can forfeit if our sincerity, if they are not satisfied.
One more defect was what?
Regarding Lordship, bank guarantee.
Bank guarantee. There's also such.
Ours is, yes, Lordship, but otherwise financial soundness, Lordship, they were satisfied. The authorities were
You are supposed to be
satisfied.
from the nationalized
National
bank.
Bank, but we submitted from
After-
the cooperative bank.
I think.
Lordship, but the only difference is that their defects were, as regard eligibility, they were not eligible at all because they did not have a pollution certificate and insurance certificate at the time of submission
It's
of the
okay,
bid.
we're not concerned about it. They have not been given.
Yes, but Lordship, that is where they.
The which defect also
Lordship.
equally yours too.
Otherwise, Lordship, only my submission here will be they did not have the locus to even file a writ petition.
So that will be again a matter of form. I mean, technical.
No, it's regarding
In
eligibility.
substance, in
There is a
substance.
substantial defect.
You are also have the your BD were also having a defect of substantial character.
But
Say, for example, the
Lordship.
bank guarantee.
Lordship,
You were supposed to be a nationalized bank.
Lordship.
Submitted from Apex Bank.
Yes, but otherwise our financial soundness is, they are satisfied by our financial soundness, Lordship, the authorities. That is the difference. This is a very big difference, Lordship, because
Well,
since,
we'll do one thing. We'll fix it after 2 weeks. You don't finalize. You have already.
we have already
Don't
started.
finalize.
We have already started.
No, we are not stopping it, but
Well-
don't finalize.
Well,
That would be better. Not
Lordship,
it. But privacy were. Nahi?
Well, that's why last time I said, my lord, my lord,
Because
who is more,
two substantial defects. The tender authority, I mean, the board has not noticed. Only one small, I mean, which can be
Lordship.
said to be not substantial.
Because
That
of,
is the only the tender authority has noticed. But the petitioner is brought through the RTA information.
no, Lordship, even the
This will be
tendering
two
authorities, Lordship, they are satisfied that the all other anomalies which the writ petitioner brought in, they are not correct, only these two. And otherwise, it, Lordship, the law is that it is upon the tendering authority, Lordship, to decide whether the
But-
defect
but-
is substantial or not substantial, Lordship.
Once we find that there is substantial, it's the defect is persistent on the basis of the record, we cannot shut our eyes. See page 19 of the internal page of the judgment, impugned judgment. Your only defect has been shown. Truck number so and so, insurance expired on 03/01/2025. This is
Lordship-
the only defect you have been shown.
No. This is one defect, but Lordship, at the time of submission, our insurance was, Lordship, valid, but it is bound to expire and we immediately renewed it, Lordship.
No, it's okay. What
Lordship.
I'm trying to indicate you is that the board has only noticed this defect.
Only one.
Lordship, not the others. Others, authorities have
defects which were
accepted, Lordship.
substantial. That's the reason. So prima facie anyway. But once you finalize, this will be unnecessary. Appeal will be unnecessary.
No, that's why, my lord,
Till,
said,
till, till next date, you don't finalize. All right. Her
Lordship, P.
MS
P. Borwa,
P.
Lordship.
Borwa, learned counsel for the appellant, as well as, and also her Mr. R.H. Nabam, learned additional advocate general for the state, non-appeals for the respondent number 7 to 10. 7 to 10.
7 to 10, Lordship, private respondent.
Respondent to despite service of notice. Next para. Learned counsel for the parties have agreed that matter may be listed for final disposal. After, we'll make it 10 days or 2 weeks.
my lord, after a week, my lord,
After a week.
after a week.
After a week, madam.
Lordship,
Because, my lord, lordship will be saying, if not final or not to finalize, my lord.
No, I'll say that don't finalize.
Don't
I'll say
finalize.
that don't
Then, my lord, 1 week, my lord, urgency will be there, because it's a supply of food grains, my lord.
Yes,
It's a
yes, we
supply of food
understand,
grains.
huh? After a week, huh? Next para. It is submitted at the bar that the pursuant to the order of this court that is 23/10/2025, the judgment and order which is impugned in this intercourt appeal, a fresh NIT has already been issued and is the process is on. Mr. However, the process is on, however, same is yet to be finalized. Next para. Considering that the judgment and order dated 23/10/2025, by which the respondents have been directed to issue first tender in respect of what?
My lord, it's a PDS wholesale nominee come carriage contractor, my lord.
PGS wholesale come nominee for transportation of food grains of the which district?
Lordship, Pakke Kesang
Pakke
district.
Kesang. And the present appeal is under consideration. We deem it appropriate to direct the responding authorities not to finalize the tender process till the next date of listing of the matter. List after 1 week. On you, one specific,
Lordship, on 2nd June,
2nd
2nd June, my lord.
2nd June is
It's a Tuesday, my lord.
Okay.
2nd June is a Tuesday, right?
Second day.
Malo only malo I'm sorry for intro. Only malo problem malo if malo the authority malo if they already approved the malo fresh tender. In that case, again malo we have to file miscellaneous application for modifying the order. That's why I said malo. If not malo, if your lordship could add.
Decide on second.
Very well. Lord,
Deeply obliged, my lord.
Item number 4,
गरम हो रहा है
पूरा फुल दिया 16 में पूरा 10
Appeal. After a week.
item number 5,
from other side.
Yeah, this is also something.
My lord.
Yes.
Here, prosecution sanction have been granted against the alleged accused since till now they haven't granted. So
Prosecution sanction has been granted.
not granted till now.
Not yet. No, not yet granted. Have you seen the last order?
Yes, my lord. This is still evidence.
You cannot do that.
My lord, on the part of the state government, my lord, various communication has been made to the central government, Union of India, Ministry of Defense, and Department of Military Affairs. But on their part, still there is no any response.
Malad, as per the instruction, Malad.
Learned Deputy Solicitor General is there.
Malad, as per the instruction, Malad.
Hmm.
Malad, that prosecution sanction has not been granted, Malad.
Not
Today's
granted.
office. Not granted, Malad. So therefore, Malad, for quashing the another Malad, the proceeding is going on. It's still pending before this honorable court, Malad.
Because they haven't granted the prosecution sanction, so that's why that is pending.
Charge sheet has been filed against these officers. Malad, again, no
The
prosecution.
officers, they have filed a quashing petition.
Malad.
This is pending.
Yes, Malad.
Matter is being stayed, man.
Therefore, prosecutor, they have not proceeded
Yes, Malad.
to consider the issue, granting of prosecution sanction.
Malad, it seems that Malad prima facie, Malad, the ministry is not Malad inclined to grant Malad the prosecution sanction is because Malad what they are contending is Malad. It is during the course of the Malad the official duty just deployed in the law and order problem, Malad.
Is the case where the petitioner or the respondent praised for referring it to army? So,
No such prayer.
Malad, in fact, Malad, in that proceedings, Malad, I am not the counsel, Malad. They are engaging is the central government.
Pending here.
Yes, my lord.
Pending here.
No.
Yes, my lord.
in this court, my lord.
कोर्ट नंबर 5 में चल रहा होगा उसमें तो नहीं है फिर करना है
Is this last order?
Last
Madam, otherwise, what's your prayer here?
we are seeking for compensation and investigation.
Investigation too, it's charge sheet has been filed.
Charge sheet have been filed, but after granting the prosecution sanction, they will file the supplementary charge sheet as per the status report. And it is for the end of justice. So till now they haven't received they haven't got the justice. If they won't grant the prosecution sanction, trial won't proceed, and there won't be any finality of the case.
In that case, we'll list it for hearing, final disclosure.
How,
Final disposal.
Your Lordship, till now they won't grant.
On its own merit.
Till now they haven't granted prosecution sanction. So how? At least they should give the reason why.
We'll see, we'll decide on the basis of this, your, whatever materials you have here, we'll decide on its own merit.
Yes.
This period.
Yes, ma'am.
And MST, some land counsel for the petitioner.
Yes, sir, 8 take, yeah.
And 7.
Okay.
No,
There are 9.
they are claiming only 4.
Okay.
So investigation is already.
Is there any reason for not granting prosecution sanction against the accused?
Malad, as per the instructions, Malad, it is during the course of Malad discharging their duties, Malad.
No, that is there. But if he is claiming that, then if is it his prayer that he should be tried under the Army Act court martial?
No, man.
Then in that case, if he is not making such prayer also, then the prosecution sanction has to be granted.
Malad, that prayer is also not Malad.
Then in that case, the prosecution sanction has to be granted.
Malad, prosecution sanction, granting of prosecution sanction is one thing, Malad. And Malad, fairly, Malad, for granting prosecution sanction, it cannot be also insisted, Malad. As because it is due completely.
No, there has to be some reason. He has to give reason.
Completely,
Why?
Malad, it is the administrative, Malad, administrative, Malad, works. Where, Malad, if deems necessary.
Cannot keep it on the shelf.
Malad, that has been already, Malad, that has already been, Malad, communicated, Malad. So therefore, Malad, without
Communicated of what? Rejecting or granting?
Either reject.
granting, no, rejecting, Malad.
Has it been?
Malad. The prosecution section,
What we wanted to know.
Yes.
Malad, that, Malad, of course, that letter is not communicated,
What
Malad.
is number one, essentially for compensation, and number two, prayer for hand over the investigation to investigate independent investigating agency
Malad.
like CBI. So once see, for example, if you find that on materials, if the investigation, if it is been carried out, culminating into filing of charge sheet, then next step is to grant or reject, consider the prosecution sanction.
Malad.
If you have not done it, if you have done it, it's okay, we'll see. That is what we are fixing the matter for that only.
Malad, I'll come with that, Malad, the written instruction also, Malad. As per the Malad, the communications, Malad, the prosecution Ministry of Defense, Malad, they declined to, Malad, the grant prosecution sanction, Malad.
Who is the authority?
Malad, Secretary, Ministry of Defense, Malad.
They have rejected.
Malad, the rejection, of course, order is not there, Malad. There's that communication.
Let him produce the order. We'll pass it.
Communicated, Malad.
We'll record that and they will fix the matter after 2 weeks. You produce that written instruction. Are you sure?
Malad, one thing.
See, we are not saying that it should be granted
Yes, Malad.
or it should be rejected.
Malad.
But you have to pass some order.
Malad, otherwise also, Malad, the
Just
period.
because you have the authority to grant or reject, you cannot keep it in a cell.
Malad, granting and non-granting, Malad, it is, Malad, it basically,
To grant, don't grant, reject it.
Malad, basically, if we,
Some orders.
Malad.
Hmm.
Malad, basically, if we see the Malad, if we peruse the Malad, the Peria portion, Malad, this is basically Malad, the claiming for the investigations to be done by Malad, CBI, Malad. Malad, now at this stage, Malad, what Malad, the submission would be, Malad. If Malad, it is handed over to the CBI, Malad, it is the only part on the Malad, the part of the investigations authorities to Malad, whether to obtain the Malad, the prosecution sanction or not.
See, last occasion, what we have recorded,
Malad.
although you have submitted, it has nothing to do with the
Exactly, Malad.
But they have sought for a investigation by the independent agency.
Correct, Malad.
Rather than the regular
Yes,
agency.
Yes, Malad.
So once the investigation is completed,
Yes, Malad.
once it is complete and the charge sheet is filed, I mean, this is something, reworking on the thing, redo the thing will not be, I mean, appropriate. That's the reason I said we said it's relevant.
Yes, my lord. That was the, my lord, the exactly, my lord. However, my lord, even if, my lord,
You have filed the affidavit.
yes, my lord.
Whatever you want to
Long
file
days
it,
back,
file
Bharat.
it, will not say anything, we'll fix it for hearing, we'll
My lord.
consider its own merit.
Yes, my lord.
Okay.
Yes, my lord.
Yeah.
In the
Number one, whether his compensation can be
That is, my lord, one aspect, my lord.
considered under the public law remedy,
Yes, my lord.
or on the basis of the materials, will consider that whether the investigation has been properly done or
My
not.
lord. Exactly, my lord.
Has it not, has the charges not been filed, matter would have been different. We could
Yes,
have
ma'am.
proceeded. We had the matter.
Yes, my lord. Here, my lord, the petitioner, my lord, they are not saying anything, my lord. The investigation done by the SIT, my lord. My lord, I believe, my lord, they are satisfied. And after completion of the, my lord, investigation, they filed a, my lord, charge sheet, right, my lord? So meaning thereby, the investigation part is almost over. Once charge sheet is filed, my lord, the investigation part is finished, my lord.
As per
Except for the prosecution
as per
sanction.
their status
Then-
report, they have said that after prosecution
That's
sanction, they will file
Ek minute.
supplementary charge sheet. So supplementary charge sheet, there will be something. So they are saying
All
that.
right, but you have not said anything on, my lord, the investigation done by the SIT. Are you challenging the investigation done by the SIT? No. And
Yes,
that-
why you are saying that it should be handed over to independent investigating agency?
But
Your
another-
lordship, till that time,
Have
they
you
have,
find out something, some
Wrong.
lacunas in the present investigation?
your lordship, till that time, they haven't,
Now we're asking,
now,
now,
it is already proceeded.
are you
But
only confined to the compensation part?
no, your lordship, investigation, because we are seeking investigation because to get the
Independent authority.
justice. But till now, it is in the trial
Although
process and
the-
trial is also not proceeding. That's the
Although
thing.
we have the power to direct for investigation by CBI or an independent agency, unless material source,
Yes,
there must be something.
we are agree with the SIT
If you
investigation,
agree with, you don't press this prayer.
but
See, we just cannot, on the drop of a hat, we cannot direct for CBI and all other things.
as per their status report, there is something. So they want to file supplementary charge sheet. So it is there. It is on there that they are saying
Do
that
you
they will
agree
file.
do you have no any doubt about the investigation?
No, no, your lordship.
In that case, your prosecution section would be, I mean, we are not saying that you should grant. Is it required?
My
Because
lord,
they are not doubting the investigation.
my lord, another
So you are, I think, basically will record it.
Yes, your lordship.
You don't press this prayer number 2.
Yes, your lordship. Because they are going to file supplementary charge sheet.
Huh.
So we will see. And they have said that they have filed charge sheet against, and it is on record that they have fired 16 arms. So it is their cartridges are found from there that they have filed.
We'll hear it on the compensation part. Right?
Okay. But
my lord, another subsequent development is during the course of hearing of this case, my lord.
she has to bring on record the subsequent development. That's the time if they are satisfied, not satisfied. Because of such. Then in that case, she has to be clarified. She has to clarify.
My lord, that's subject to correction, my lord. There is another problem, my lord. My lord, judicial inquiry was done.
Exactly.
The judicial inquiry says, my lord, there is nothing, my lord, all play by the army officer. That also they have not challenged, my lord. So two things, my lord, they have not challenged. The inquiry by the SIT, the judicial inquiry, my lord, they have not challenged, my lord. I think
Well, when the charge sheet was filed,
Charge sheet, it's in the status report.
बाद में बैठ के इसका बात करके I think it will
should have-
Your lordship, I guess charge sheet haven't provided to us because it's going in the trial board.
This is a subsequent development. That means
Yes, your
then
lordship,
probably you may have
the
to bring
status
that on record.
report is
Yes.
filed on 21st Jan
after filing of this
2025.
my lord PIA.
So we haven't received the charge sheet and all these things. We just received the status report.
And
They
probably
have filed.
because there has been subsequent development. You may
Yes,
have to file.
because they want to file this supplementary charge sheet. It means there are some development.
No, that now also subsequent development is that charge sheet has been filed.
charge sheet, main charge sheet have been filed,
So
but
you
they
have-
are waiting for
Because
prosecution
because
sanction.
your prayer number 2 has changed. Your prayer number 2 is to hand over. If the case has already been investigated and charge sheeted, nothing remains there.
But
And only if you are not satisfied, then different case. Then in that case, you have an option.
We are also sought for the this arresting of the culprits, but till now they haven't.
See, now you say that the charge sheet already filed.
Yes, Your Lordship.
From there, you'll come to know what is the progress or what is the findings, I mean.
Yes, but we
Ah.
haven't received the charge sheet.
And you have to apply for that. Because this is subsequent development. Unless you are not praying, not pressing this prayer number 2. You have to bring on record the subsequent development and then make a prayer accordingly.
Yes, Your Lordship. Then some more time may be given, so we.
Who are you?
That
Who are
that is
you?
better.
I'm social activist.
What social activist?
Working on various human rights related issues.
Okay. I think you have to file additional affidavit, and then on the basis of the additional affidavit, if you say if your grievance remains that not satisfied, or as per your additional affidavit, then the learned additional AG, not additional AG, okay, if there is any grievance against the state,
Yes, ma'am.
state will you make a prayer, and if against the non granting of prosecution sanction, then they will reply, why not?
Yes,
This
then
court
some
will
more time
also
is
ask,
given, so we will look into the
that will
charge
be
sheet
better,
and-
I think,
Yes,
instead of fixing it because it's not right for hearing, sir. Not yet right.
And my lord, another subsequent development, what exactly I wanted to
How
point
many
out.
subsequent developments?
Two subsequent development. One is cheated, another is judicial inquiry report, my lord. In the judicial inquiry report, my lord, there is no disclosure of anything which has to be, my lord, done, investigations to be done by this investigation agency, my lord. In the subsequent, my lord, even judicial order of this honorable court, my
That
lord.
cannot be subsequent development. We have taken note of the moment this was direction.
My lord, after report, my lord.
Is from by the
Judicial inquiry report,
to the direction of this court only.
yes, my lord.
That's
If
not a subsequent development.
therefore,
That
my
has been
lord,
brought on record.
so
We have
therefore,
taken
my
note
lord,
of that.
if Lordship peruse the, my lord, the judicial inquiry report, my lord, it is prima facie case, my lord, there is no, my lord, any full flame, my lord.
Then why there is a charge sheet?
Charge sheet is before the judicial inquiry report.
Are you sure?
Charge sheet is-
No.
No, probably.
My lord, if, in fact, my lord, I am not in that, my lord.
No.
This PIL was filed in this during the pendency of this PIL, my lord.
So number one, first development, subsequent. There is no subsequent development. There's no second. What is your so-called second?
Second subsequent development, as I pointed, my lord, that inquiry report, my lord. In inquiry report, my lord, there is no, my lord, any my lord, the disclosing of the facts, my lord. It has been done by the, my lord,
What
the
inquiry report?
judicial inquiry report.
That is passed. That is the first one.
Yes, my lord. Even if, my lord, if
That
we,
we have taken note of it.
yes, my lord.
And the
That the
judicial
charge sheet-
inquiry is caused pursuant the order of this court.
Yes, my lord.
So this we have taken note of. That
Yes,
is
ma'am.
brought on record.
Then, my lord, that is if that is the first, my lord, then second is charge sheet, my lord.
I'm saying it's not a first or second,
Yes, my lord.
even not third. There's
But
no
my lord-
development.
But, my lord,
That we have taken note of. What is the development here now at present? What is the status?
my lord, what, my lord, I make my lord submission is in
It's fair enough. She may not press the.
so therefore, my lord, this what
She doesn't have any.
my lord,
doubt
at this
on
stage, it is not required, my lord. It has to be disposed of, my lord. It's because the two reports has come.
The most important thing and the primary, the prayer is for compensation.
That part, my lord. That part, my lord,
Anyway,
we are not disputing, my lord.
So we'll-
Okay, grant. Yes.
Should I record your submission that you are not pressing the prayer number 2?
Your Lordship, I may like
Be
to.
fair.
I may like
It's a
to.
public interest litigation.
Your Lordship, it may not bring in the record because
Then why you have said so that you are not?
because As per
You are satisfied with the investigation?
that thing, I have to discuss with the senior because now it's saying that we have to bring the charge sheet. So we have to look into the charge sheet.
Ha. Please take down. Heard MS Tisamo, Learned Council for the petitioner. When this petition was filed?
It is 2020, Your Lordship.
21/11/2020.
We'll have to dispose it of unnecessary.
6 years.
Can you argue? We'll hear it.
Your Lordship, time may be given. We will see the charge sheet.
What's there? If you only
Because we don't know what is in the charge sheet. We don't know what is in the
We'll
charge sheet.
grant you, not 50 lakhs, lesser than that.
Your Lordship, time may be given for some time.
You don't want.
Time may be given. Because money is not the only thing we are seeking here.
Other than that, there's nothing.
Let's see, Your Lordship.
When you don't press the prayer number 2,
Let's see, Your Lordship.
and Mr. Arif Nabar, London Council, London Additional Advocate General.
2 and 7. 2 and 7.
Then you write first,
Yes, ma'am.
M. Kato, London DSGI. For respondent 1,
Only one, madam.
1, and then Arif Nabar, then
2 and
For
7.
9 months.
2 and 7, then
9.
El Kurdu, London Special PP.
My lord.
Crime branch. What is this?
SIT.
SIT, man.
SIT. Huh? For respondent number
9.
9.
Scientist.
Having considered that this public interest litigation is pending since 2020. And within certain developments, including the judicial inquiry and filing of charge sheet, as well as and the consequential consequential granting of charge sheet, prosecution sanction, we deem it appropriate to list this matter for final disclosure after 2 weeks.
Yes, sir.
After 2 weeks, the Learned Council for the parties in the meantime may file affidavits as regards the present status, as regards the status of the matter, including the granting a consideration of granting prosecution sanction consequent to the filing of charge sheet. List of as agreed to by Learned Council for the parties, have this matter be listed on. We'll give the fixed date. We'll dispose of the
Any date
matter.
you want? Any
Sir.
2 weeks. No specific date.
No, sir.
Then make it 3 weeks. 3 weeks.
Yes,
You may bring whatever you would like.
yes, ma'am.
Because it's of no use passing every day. We cannot pass.
Madam, I'll come with that.
They're directing the same.
Yes, ma'am.
I mean thing.
I'll come with.
Item number 6.
You also file, huh?
Yes, Your Lordship.
Whatever you want.
My lord, as for the last status report, and the road was targeted to be completed by this 31st of May.
Hmm.
But I've taken verbal instruction with the concerned authority. It is yet to be completed because
during the in the meantime, there was incessant rain, and now the black topping part is to be done, and it cannot be done during the monsoons. Now everything has been arranged, all funds are arranged, sanctioned. Now only the part for black topping. Now that
This has been constructed by the department.
no, Marat, department is monitoring. There is contractor is there.
Some America or Japanese contractor or what?
No, the contractor is
It's respond number 13 and 14.
13 and
It's
14.
Gammon India Limited.
Gammon India.
Indian.
Yes, Your Lordship.
Yes.
The contractor doesn't know the climatic condition of the state. You have said you'll complete by 31st May, and then when you could not complete it, then you say
It was
because of
targeted to
the-
be completed, my lord. Of course, my lord.
Your Lordship,
third MST.
Your Lordship, I may be here.
We'll direct them to file. We'll record his submission and then we'll record.
No, Your Lordship, it's been third time this is that they are giving the deadline.
The progress percentage of work.
In 1 year, they have just constructed 14 kilometer, and in last year they have granted 12.50 CR. In that monetary amount, they have just constructed 14 kilometer from last February till this March. So it's just 14 kilometer. It's on record. The additional AG have.
Yes, please. That is not
On order of 4/11/2025. If Your Lordship may look that.
And when you can complete?
My lord, now the monsoon season also has arrived.
5 kilometers only. What is the total?
My lord, as
They are saying just now that length is 25 kilometer they are left with, but from the petitioners it's saying that till from last February they haven't constructed anything, so it is contradicting the submission of the authorities
inquiry
and
may,
the petitioners.
be directed, because we are saying, as per our report, we are saying this. We have given that now balance work for WBM is 9 kilometer and black topping is 19 kilometer. Now, if she is disputing that, there has to be an inquiry. Who is speaking the truth?
And let the respondent number 2 who have been withdrawn and the respondent number 13, 14 who are the executing agency, they should file the affidavit, because it's been 3 years that they haven't filed any affidavit.
Who is for the contractor?
Contractor,
Last time he was online.
the executive engineer is filing the status report. If it is, if this honorable court directs that the contractor, Gammon India, to be.
He's a party. Notice has been served.
Yes, we have already. Last time he have appeared online.
Yes.
And the respondent number 2, because they have withdrawn the amount after filing.
Number 2.
Respondent number 2 is Northeast Council, Secretary of Northeast Council.
They have
provided the fund.
They have cancelled.
They have cancelled, but they haven't given reason why they have cancelled.
Cancel means what?
No.
Fund was first, the original fund came from there, and after filing this PIL, they have withdrawn their amount of 20 CR. So they haven't given any reason that why they have withdrawn. So at least they are liable, because they can't just give the fund which are of the people's taxes. So they just withdrawn without giving any reason why they are withdrawing. After 16 years, they have withdrawn. That they haven't given any affidavit regarding this PIL that they have withdrawn. So it is the liability of them and responsibility of them to inform this court that why have they withdrawn from the
funding. It's a state.
Initially, this project was sanctioned by the NEC. And because there was considerable delay, and there were so many cases also, corruption cases and all involved here, and there was a timeline also provided by the NEC. Because of all this long pendency and because of the lapse of the timeline, they have withdrawn the fund earlier sanctioned. Now it is the state government is sanctioning this project, madam, by its own state fund.
So you have filed the status report.
Yes, we have filed.
24.
Yes.
But they haven't provided the fund, how much fund they are left with and the
No,
UC.
no, we have asked for the status report to
Is-
file the status. What is the status report?
They have filed on,
Madam will find it.
Affidavit.
Yes, in the form of an affidavit, we have filed a status report.
they have filed on
on
19/03/2026.
19?
19/3/2026.
1903.
Yes. Page 212.
Hmm.
And then internal page 214. In para 4 also, the fund of 9.5 crores was received, sanctioned on the 25 of February 26. And then the balance works have been shown, my lord, in the column at para 5. So the balance work for black topping is 19 kilometer and WBM 3 is 9 kilometer. And in the remarks, we have stated that the work is targeted to be completed by May 26. Now, as per my instructions, that because in the intervening period, there were incessant rainfall in that area, so black topping couldn't be done.
So when you elected,
No, my lord, it will now, my lord, everything is ready. The fund has been sanctioned. Now work has to be done. But with this unpredictable weather condition, we cannot even give any guarantee any timeline because the monsoon is arriving. And black topping done just to complete it during the rainfall, it will be useless.
Let us report financial.
May 20.
Mhm. Mhm.
Are you saying that?
This is helpful. And because of the possible and also good one. Doing what to do?
This matter is listed after filing of the status report, or has it been?
The latest status report we can obtain, but as per instruction, it has not been completed.
We want you to, it just cannot be. See, we understand the practical difficulty because of the rain and other thing. But then it cannot be allowed like this.
Yes, my lord.
We have accepted your, we see that we thought you will be true to your words and the
Yes.
affidavit that you will, I mean, contractor monitored by you, that you have said in that works progress and target to be completed by May 2026.
Yes, my lord.
So we'll grant you 3 weeks. You bring on record
The latest.
what is
status.
not latest, not only the latest, the complete the plan to complete, irrespective of whether we were not see practical difficulty everyone would understand, but it has to be completed.
Yes, my lord.
If everything is ready, what's the problem?
My lord, in that event, the respondent number 3, the executive engineer as well as the contractor, both may be directed because the contractor also is there.
We'll call them in that case. You file the work plan completion, work plan for completion
Yes.
in view of this thing, and will direct the executive engineer and the contractor to appear on the next day.
Yeah.
Third, MS Tiso Land Council for the petitioner. Next, the an additional affidavit is filed pursuant to the order of this court, that is 2402/2026, which reflects that the works in question are under active progress and the remaining works would be executed. Remaining works to be executed is about 19 kilometers out of total.
On last occasion, it was 45 kilometer. Last occasion, it was 39 kilometer.
No, total
Total 81 kilometer.
out of 81 kilometers. And on the date of filing of the affidavit, the said work was targeted to be completed by month of May 2025. Today, Mr. N. Ratan Lalit, Additional Advocate General, on instruction submits that the works would not be possible to be completed as targeted, which was in this month, in the month of May 2026. But your affidavit is also wrong. You have said 2025. Para 3. Page 213.
213. My lord,
It's a typographical
yes,
mistake.
typographical mistake, my lord.
2025. It should be 2026.
26.
May 2026. Due to, although although all the materials are ready, but due to incessant rain in this during this monsoon season, Mr. Next breath. Take it. Serious note of the conduct of the respondents, including the conductor. And in construction of the road in question, we deem it appropriate to direct the respondent, including the contractor, to bring on record that the status, the work plan, status of the work include the IE work plan, which would include the financial aspect by next date of listing, next para. Considering the list of further considering the issues involved, we direct the executive engineer,
Yes, madam.
PWD,
Siang Tajo Division.
Siang Taja Division,
Yes, madam.
Yes.
namely Sri,
My lord,
you find out the name.
yes.
Or,
Ojing Pajing,
name is not required. Okay, name is not required.
not required.
And the contractor, the proprietor, or what do we call it?
My lord, may I simply say the contractor,
Contractor. Respondent number
13 and 14.
13 and 14.
13, 14. To personally present, to appear on the next date.
Yes, my lord. Fixed date may be given, my lord.
Hmm.
In the event,
This matter on when?
16 June.
16
June.
16
6.
Yes. Let us hear from them also.
Yes, my lord.
Much of.
Item number 7.
Lordship, service is still awaited, Your Lordship, for respondent number 3.
Mr.
P. Wangpan, Your Lordship.
Huh?
P. Wangpan.
P. Wangpang.
Yes, Your Lordship.
Wangpang,
Yes, Your Lordship.
Learned Counsel for the appellant.
Yes, Your Lordship.
Await service report. List after the writ petitioner. Petitioner.
Yes, sir.
Mr. T. Wangpang. Your name is there.
Yes,
T. Wangpang, Learned Counsel for the petitioner, is present, as well as Mr. and Mr. M. Kato, Learned DSJ, are present. Huh? Await service report. List after 3 weeks.
much of that.
Item number 8.
8 to 10.
Your Lordship,
Report,
yes,
report.
yes, Your Lordship. This has been restored
These
back.
Matters.
Can, next week, Your Lordship.
Any other appropriate bench without one of us, my name.
Obliged.
Item number 11 and 12. Sorry, item number 11.
Yes.
Severe service is here debated.
Okay. Mr. You are for?
I'm on behalf of Tapat Tagum.
Mr.
Council. El Tikat.
El Tikak.
El Tikak.
Council. Appears for Mr. Appearing for Mr. T. Tagum, London Standing Council, Education Department is present. Award service report list after 4 weeks.
Item number 12.
Same. Yes.
Santosh.
Same order. Item 12. Please put.
Item number 13.
Lordship, in this matter, the paper book has been prepared, but then if the amicus is being directed to prepare a appeal memo, Your Lordship, there is no appeal memo in this petition.
Okay. Paper book is prepared. It's okay. Paper book has already been prepared.
Yes, Your Lordship.
It's okay. We'll list it for hearing. Who is for Americans?
Mr. J. Jin is there, Your Lordship.
Where he is?
He has informed me this morning that, Your Lordship, he won't be able to come because of.
Where this is listed for?
This for orders, Your Lordship.
Okay.
Mr. J. Jin is there, Your
Where
Lordship.
he is?
Lordship, I am appearing through VC, Lordship.
Yes.
He won't be able to come because of.
Where this is listed for?
This for orders, Your Lordship.
Okay.
Mr. J. Jin is there, Your Lordship.
Okay. Have you received the paper book?
Yes, Lordship, I have received the paper book, Lordship.
Yeah.
Yesterday I have received. Lordship.
Heard Mr. Judge Learned. Legal Aid Council or amicus?
Lordship, it has to be amicus, but they have written it as.
Okay,
legal aid.
amicus for the appellant and Mr.
Yes, Lordship, I have received the paper. Yesterday I have received.
Heard Mr. Who is there?
I have actually listening to the mobile, I suppose that's why I have to meet him.
Okay, and MS Tijin Learned additional PP for the state. List the matter for hearing. Up to 2 weeks,
2 weeks,
3
Your
weeks.
Lordship.
2 weeks,
2
3 weeks.
weeks. 2 weeks, Your Lordship.
2 weeks.
Item number 14.
This is an application under Section 5 of Limitation Act, paying for delay of 5 days condemnation for preparing the accompanying.
How many days?
5 days, Lordship.
What is to be done in that case? 5 days.
Same thing for the
Our suspension.
suspension was for actually
Limitation period,
limitation.
5 days.
So,
Lordship, I have no objection in the limitation, Lordship, because this is a criminal appeal.
heard
G. Fukan, Lordship.
Mr. G. Fukan learned counsel for the applicant and also an MS L. Haggett learned addition PP for the state. Next para. This is an application under Section 5 of the Indian Limitation Act 1963, praying for condemnation of 5 days delay in filing the criminal appeal against the judgment and order dated 10/03/2026 passed by the learned sessions as UPA in sessions case number 47/2017, whereby the appellant has been convicted and sentenced to undergo imprisonment for life under section 392/2001 read with section 34 of IPC.
Yeah, I'm suspension.
And rigorous imprisonment for 10 years
I'm suspension.
under section 392.
Yeah.
Read with section 34
Put up in a
and
karela.
rigorous imprisonment for 3 years under section with payment of fine of with the fine of rupees 5,000. You take this from para 2, huh? Page 2. with default stipulations. Next, where is the grounds? Where is the explanation for delay in filing the appeal? Next, paragraph. You are satisfied that the appellant could explain explain the delay of 5 days in filing the criminal appeal, which is German. Accordingly, we deem it appropriate to condone the delay of 5 days in filing the appeal, connected appeal. Rest of the delay condone. The IA stands disposed of.
High Lordship.
This may be listed again, but Lordship, in the connected Lordship, out of same FI Lordship, last week Lordship, one appeal was filed Lordship, and it may be listed along with that appeal Lordship. That was
The criminal appeal has been filed.
last week Lordship, criminal appeal 11 AP 2026 Lordship.
It was
Out,
listed.
yes, Lordship, out of same FI Lordship.
No, there only will say, no, in view of the, no, this will be automatically listed, is not it?
Along with the criminal appeal 11.
कितना है number?
11.
11.
Let's go. It should be listed only once the delay is condoned.
Lordship, yes, Lordship, admitted, notice was issued, Lordship, and it was listed for 3 weeks for the IA Lordship, for suspension of the order Lordship. Otherwise, Lordship,
We'll say that list the in view of the order passed in IS so and so, list the criminal appeal number 12 of 2026 after a week.
Item number 15 and 16.
I'm appearing on behalf of Mara. In the PL, I'm both the respondent number 2, and in IA, we're applicant. As for the previous order, instruction from the Content Department has not yet been received. So, instruction has not yet been received from the Content Department. So sometime maybe given.
Yes.
Instruction has not yet been received from the concerned department.
What concerned department?
Respondent number 2, NHI division. NHI division. For my lord. Oh, sorry.
What this IA is for? IA is for?
Lordship, IA, now by filing this IA, they are saying that they have already communication letter has been already given for realignment of the road, Lordship. Now, accordingly, on previous occasion, this honorable court has made an observation that it was only a mere entrusting, Lordship. But it has to be come up with concrete information whether the realignment has been done or not. And if it is done, whether realignment would mitigate the grievances of the petitioners, Lordship. That instruction was supposed to be produced by the respondent number 2. whether the process of realignment has completed or not.
Applicant, NSDCL.
Yes, Lordship.
NHIDCL.
Yes, Lordship.
So you want some more time?
Yes, my lord.
Why? When you have already filed IA, saying that what is to prepare, obtain is whether after insisting consent. Okay. Then we'll list after 3 weeks.
Lordship.
And Mr. K. Learned Counsel for the petitioner. Mr. You are also.
Yes, I put respondent of both. Number 1 and 3.
Mr. M. Kato learned DSJ for respondent. 1 and 3, and Mr. And
4 to 9.
4 to 9, and Mr. London additional petition for 8 to 9. Mr. Your name, please.
D. Pangu.
B. Pangu.
D. Pangu. D.
D.
Yes, my
D.
lord.
Pangu, London Council. Your name is there
Yes, my lord.
for the respondent number 2.
2, yes, my lord.
Submits that it may be granted for the 3 weeks time to obtain instruction as regards in terms of the in terms of the order dated 30/04/2026. Praise the Lord, list the matter after 3 weeks.
Deeply obliged, Lord.
Item number 19.
Yes.
Your Honor, this is a jail appeal.
Hmm.
It's 302. He's been convicted for life imprisonment with a fine of rupees 3,000.
Hmm.
Page number 8.
Just wait. Yes.
Page number 1 is
Hmm.
the FIR.
Hmm.
It states that it is to inform you that today on 6/8/2019 at around 08 hours, Wan Chao Bitupon Chaupu of Manhofai village who
SB Dara, Land Council for the amicus,
LSC.
Legal aid council for the appellant, and also have an STT Land additional PP for the state. Hearing concluded, judgment reserved. Okay.
Deeply.
Announcement of judgment of item number 1.
May
Writ petition dismissed.
Judgment item number 2.
The writ petition allowed.
may it please your lordship.
Yes.
Lordship, I would like to make a mention of item number 15. towards item number 15. 15. Lordship,
Ah.
I am the instructing counsel in this case, and I have been under the weather for past couple of days, and I have been unable to appraise the lead counsel, Mr. Edhar, to proceed with the case. So, Your Honor, may adjourn for the day. With the consent of the other side, I am mentioning this matter.
Okay.
Your Honor, if Your Honor, furthermore, I'll seek just a small indulgence. If the matter may be fixed on 16th, the counsel leading us would be there on 16th. So, if Your Honor may fix it on 16th of June.
On the prayer of Mr. N.R. Surara,
Yes, Lordship.
learned counsel for the respondent. And with the consent of the learned counsel for the applicant, let this matter be listed on 16 June.
Lordship.
16/06/2026. Okay.
Very much obliged,
Lordship.
Lordship.
Interim Lordship.
Interim order is there.
Yes, Lordship.
Interim order passed, the letter shall continue.
Lordship.
Obliged,
Much
Lordship.
obliged, Lordship.
Your Honor, I would like to mention item number 6, Your Honor.
6?
Yes, Your Honor.
Yes.
Matter maybe, matter has been withdrawn, Your Honor. Petitioner is already transferred.
You want to withdraw?
Yes, Your Honor.
Yes.
On behalf of
Mr.
Tigame.
Tigame, learned counsel for the petitioner submitted. He may be allowed to withdraw this writ petition. With prayer for withdrawal is allowed. Accordingly, writ petition stands closed on withdrawal. Yes.
Much obliged.
May I please, my lord? My lord, I am mentioning 2 writ petition for listing today, my lord, for withdrawal only. My lord.
Withdrawal?
Yes, my lord.
Okay. Take that withdrawal.
Lordship, I beg to mention item number 13.
13?
Yes, I have an instruction to withdraw this, Lordship.
Mr.
S.C. Rang.
S.C. Rang, learned counsel for the petitioner submitted. He has an instruction to withdraw this writ petition. Therefore, praise for withdrawal of the same. Accordingly, writ petition stands closed on withdrawal. Yes. You are there. You record. Where is this? Her name. K. Wangma. For state respondent.
My Lordship. Lordship, I beg to mention item number 10, Lordship. The matter has become infractious, Lordship, so I may be allowed to withdraw the matter, Lordship.
Mr.
K. Meena, Lordship, on behalf of T. Garam.
K. Meena.
Meena, Lordship.
Meena, learned counsel appearing on behalf of Mr. T. Garam, learned counsel for the petitioner submitted. The writ petition has become infractious.
In this case, Your Honor, I am for the private respondent number 7.
You are Mr.
T. Nima.
T. Nima.
Yes.
Learned counsel for respondent number
7.
7. Accordingly, writ petition closed on having been become infractious.
Lordship, with the consent of opposite party, I would like to adjourn the matter listed in item number 12.
You want to adjourn the matter?
Yes, Your Honor.
So adjourn it. Why permission is required?
Leading counsel for the respondent number 5.
Pray for adjournment, sir.
Leading
you want
counsel.
to adjourn, you adjourn it. Why you would make why you should inform us?
Pardon.
Yes.
Leading counsel for the respondent number 5, Mr. B. Arun is suffering from eye flu.
B.
Arun, Arun Bingia.
And also on the ground that Mr. Bengia Arun, learned counsel for the respondent number?
Number 5.
Number 5.
And also
Mr. Your name, please.
T. Moses.
T. Moses, learned counsel appearing on his will, praise for adjournment of the matter. Adjournment of the matter. Please the prayer not been objected to by learned counsel for the petitioner and the state respondents. Let this matter be listed after 3 weeks.
Yes.
3 weeks, huh? Yes.
Lordship, herein I am for the petitioner, Lordship.
I may be allowed to file a rejoinder, Lordship, in respect of.
And in the meantime, Mr. D. Lona, Learned Counsel for the petitioner, may file affidavit in reply.
Yes, sir. Item number 9, ma'am. Yes, ma'am.
Item 9, not 9. Election petition.
Yes, ma'am.
Then
Leading council, 8 attack is getting it personal. So,
then why you have fixed it? Unnecessary. This code had to go through
yes, my lord,
last night till 11:30, around 12.
And my lord, witness number 1, 2, and 4 is also one is having a personal difficulties, and 2 and the rest. Witness number 2 and 4 are just convinced.
Okay. Mr. D. Yadav, Learned Counsel, appearing on behalf of Mr. A. Tatak, Learned Counsel for the petitioner, submits that the leading counsel, Mr. Tatak, Learned Counsel, has some personal difficulty and therefore prays for listing of the matter when?
The next available page.
We'll make it after 2 weeks. And then when this court sits, you make a mention. This is now evidence.
Yes, ma'am.
Cross-examination.
Yes.
It's not possible over the BC. Through BC, it's not possible.
Yes,
Isn't it? Mr. D. Lona, Learned Counsel for the respondent number 1.
For respondent number 4, returning officer.
2. You are 2.
For returning officer R4.
3, 4 are present. List accordingly.
Item number 3. Oh,
Item number 7. What do you want? Okay, Mr. L. Tikak, Learned Counsel, appearing on behalf of Mr. T. Tagub, Learned Counsel, Standing Counsel for the Education Department, submits that Mr. T. Tagub has some personal difficulty, therefore prays for listing. Has some personal difficulty today, therefore prays for listing of the matter after 2 weeks. Mr. Next,
Lordship, I'm appearing for the petitioner, Lordship.
Objected by Learned Counsel for the petitioner, Mr.
K. Tang, Lordship.
K. Tang.
Yes, Lordship.
Your name is there.
My Lordship, name is not there on Wakalat Dhamma, but I'm appearing on behalf of
for the petitioner.
Yeah.
Come on, let this matter be listed after.
Lordship, requesting for
2 weeks.
Lordship.
2 weeks.
2
3 weeks.
2 weeks.
2 weeks, huh?
item number 3.
Lordship, I'm on behalf of the Standing Counsel Tabatagum.
Where is the appointment order? Where is the impugn order? Impugn order.
Impugn order is at page 74, Lord.
74. Tanyang Daka, psychologist. To DTCC Yingqiao. What is DTCC?
DTCC means Lordship, District Tobacco Control Cell.
Okay. NTC.
Basically,
Where's the appointment order?
appointment Lordship at page 72.
72.
Lordship. 71 is the offer letter, Lordship.
What does it say?
In offer letter also.
No, what does it say that you are not transfer? The post is not transferable.
Yes, Lordship. Page 71, Lordship.
Not in the appointment order.
No, not in the appointment. It is specifically mentioned in the offer letter saying that there will be a fixed salary of 25,000 per month and then the post is not transferable.
Where it is?
It's just first paragraph, last line also.
There is no provision for transfer and reassignment under the program.
Yes.
Where's the program guideline?
Guideline.
Is there anything in the guideline?
Yes, Lordship. I enclose the guidelines also. It is at page number, Lordship. 32. 67 is the operative clause, 8.7 Lordship. 67 Lordship, 67.
Posting and transfer and
Yes.
is done for a particular position in the state.
Under the NH, recruitment is done for a particular position at the state, division, district or block level, and it could be at a health service delivery institution or at the state apex body. The employees should be given the choice of their posting to the extent possible. Only if there is no vacancy, should be nearby district choice and second choice be given. In case of healthcare providers, the husband and wife should be co-located or as near each other to the extent possible and any other.
NHM should not be subjected to any routine transfer. Transfer may be introduced.
Yes.
Which is vacant, the employees so desires because of the
Lordship, I'm praying for some more time.
No, it's a transfer. What time?
Let it be fixed on tomorrow, Lordship. The standing council will be here.
What difference will make?
I'm not authorized.
It's not transferable. Anyway, we'll issue notice. Heard Mr. K. Leonard Counsel for the petition. Challenge made in this petition is to the order dated 12/05/2026 passed by the State Program Officer within brackets NTCP bracket close Directorate of Health Services, Naharlagun, Government of Arunachal Pradesh, whereby two social workers within bracket NTCP and two psychologists within bracket NTPC, including the petitioner, are sought to be transferred from. They transferred to various places. List of the petitioner is sought to be transferred. A psychologist NTCP bracket close, DTCC Pasigat to DTCC Inkyong. List of next para. It is the contention of the petitioner that the post, the petitioner being appointed as psychologist NTCP under the what program?
NTCP Lordship. National
And NTCP under the
Tobacco Control Program.
National Tobacco Control Program.
Yes.
A post on what contextual basis?
Yes.
On at a fixed monthly remuneration. Is not transferable as per the guidelines of the NTCP list of. Next para, issue notice returnable by 4 weeks. Transfer posting will make it 3 weeks. 3 weeks. Next para. Mr.
Healthika.
Is there any private respondent?
Yes, Lordship. Private respondent number 5, who had been transferred in 5 days.
Okay. Then in that case, transfer from so and so, vice so and so, private respondent. That is respondent number 5. Okay. She's also a psychologist. Next para. Mr. Swenso. Tikak.
El Tikak.
El Tikak, Learning Council, appearing on behalf of Mr. Tita Learning Standing Council Health Department, accepts notice on behalf of respondent 1 to 4. No formal notice need be issued, however, extra copies be so and so. Learning Council for the petitioner to take steps for service of notice upon respondent number 5 by registered post as well as by usual process within 2 working days. Next para, having considered that the petitioner appears to be working as a psychologist, having considered the petitioner is working as psychologist within bracket under National Tobacco Control Program.
Yes, Lord.
At a fixed monthly remuneration. The post which is non-transferable in terms of the guidelines regulating the program under National Tobacco Control, the impugn order dated 12/05/2026 passed by the State Program Officer NTCP in respect of the petitioner shall remain suspended till returnable date. Till returnable date. Please stop. Since the interim order is passed without causing service notice to the private respondent, the respondents may file appropriate application for modification of vacation of so and so, if so advised. This after 3 weeks.
Item number 4.
Your assistant conservator of forest. You are?
Same.
Same. Okay. Kabit had MS and Learned Council for the Kabitter. Kabit is in the chairs.
Given the charge of the for expert melody on 13/10/2025, page 28. I've been given the posting at recovery. The person who was at recovery, he was transferred to Delhi. Then your lordship will find serial number 4.
Page 28.
28. But I am at serial number 3. I have been posted as DFO
Transfer
recovery
and posting from DFO Lohit.
to DFO recovery.
DFO recovery. Yes. Then
And DFO recovery serial number 1 is being sent to DFO Diam. And one that serial number 4 with private respondent. He has been transferred from the Bandar to Sagar. And all these orders, my lord, though it is in one, my lord, all these orders to be effective after 31st of March 2026. The orders are to be effective from after 31st of March 2026. Last column, remarks. Remarks column, my lord.
page 28.
28. Column number 5, remarks. So all these orders to be effective from that day.
Okay, effect after 31st March 20. Okay.
Accordingly, on 2nd, I have joined by the page 29, 2nd of April.
Why April?
because 31st of March is the till 31st.
Okay.
It won't be effective. It will be effective only the 1st of April onwards.
Okay.
I have given my joining report to the person at serial number 1 who is holding the charge of DFO.
Yes.
And he, by the next letter at page 30, intimated to the Chief Conservator of Forest that I have joined.
So handing and taking over.
Lordship.
Page 31. Then
my lord will find page 33.
relieving from duty.
My lord, by that time, my lord, the person who was at recovery, he has also left. I had my lord, taken over the full charge on 30th April 2026. So to the superior authority, principal chief conservator, I have reported.
Then impugn order is
Now, my lord will find all
18.5. 18.5.
18.5. The order dated 13/10/2025, which was made effective from 31st of March 2026, that has been complied with. That it has spent its course. I have joined on 2nd. I have been working regularly with all the judges. The full charges was given even on 30th April. Now, my lord, by this page 34, it is said, my lord, in partial modification of the earlier order dated 13/10/2025, I have been retained as DFO of Lohit, as if the earlier order dated 13/10/2026 has been revived. And the private respondent.
Where does it say the person? Okay. In the remarks.
In remarks. And the private respondent number 6. Pursuant to the order dated 13/10, though he has joined in Sangli, he has been given the posting in matters. So this is under challenge. First ground, order dated 13/10/2025 having already been executed. Nothing remained to be modified or cancelled. And subsequently, on inquiry, to that effect, I have also submitted a representation immediately on 19/5 at page 36, which is not disposed of till date. And from the inquiry from the office, the respondent number 3, I have come to know that this respondent number 6, private respondent, he is a permanent resident of Likavali. And being having a good maintaining a good relationship with the local MLA or the deputy speaker of the assembly, this modification was mooted, and accordingly, impugn order has been passed. It's absolutely null and void.
Any documents to show that?
My lord, I have given the statement, categorical statement, and recently, I have also the RTI information I have received. I could not annex.
Saying what? Saying what?
Saying same thing. The deputy speaker has recommended for change of the posting of the private respondent number 6, and thereafter 5 has been mooted. And accordingly, after approval and necessary, the impugn order can be passed.
You bring out record. We'll take it up tomorrow.
Ground assignee is well. So this is on that cannot be handled. Ground assigned that he is a local resident of Likavali. So therefore he is required. Whereas I on the verge of retirement.
You are alleging malafide.
Yes.
You bring on record. We'll consider that. You'll be praying for interim order. Other than, it's not that they are absolutely debarred from passing the transfer order. Even after 1 day, 2 days, if they can show the public's interest.
That is true. The record will reveal whether it is in the public interest order. But then the order having been executed, It has spent its force. There's nothing to be modified.
That's why I say it's even if it can be modified, there can be transfer or press transfer order. What's not?
Press transfer order, that's true. Madam.
It's a transfer order only, press transfer order only.
No, madam.
It consists of 4%. Earlier, how many?
Initially,
This 1310, how many?
4.
Ah,
Not all have been touched. Madam.
ah. Goba
All have
Doke,
been touched.
Keto Basar,
Only
Bajul
madam,
Sir.
myself and madam, this serial number 4, madam, private respondent have been touched. Otherwise, the person at Likabali, he has already joined into Deomali. There is no issue with that. Madam, he has not been touched.
Then where is the law that there cannot be a fresh transfer order?
No, the law is otherwise, madam, that once madam, the transfer order is executed or madam, complied with,
There cannot be any transfer order.
no, they can
In
be
future.
fresh order. Nothing to revive it or because
This is press order.
but
Although remarks it has
madam,
been, obviously when the fresh order is passed, the earlier it is shown to be modified.
So madam, that modification perhaps madam, my submission, madam.
That's why I'm saying, if you anything malafide, so that we can consider bring on record.
I am electing madam, this tomorrow. But I have categorically stated that I have not yet handed over the charge.
Who doesn't say that in the writ petition?
It's a fact, madam, the
Yes, anyway. What do you say?
Lordship. Lordship as observed lordship. Transfer being the conditions of service lordship. Any 1 day, 2 day also the transfer can be issued lordship.
But not in this manner.
Lordship. Lordship, only the records will speak lordship.
Why he has to be brought in? It's been not even it's months only. 2 months.
Lordship, that's
April, May.
That's what lordship.
Not even 2 months.
That's what I'm submitting lordship.
15 days.
Only records can speak lordship. What's the reason lordship behind this order? Or if it has been done lordship in the interest of public service lordship, that can be done as lordship as observed lordship. So I may be able to come with the records lordship.
Till then, don't release it.
Here lordship, as I'm told that lordship, capital lordship, they have already joined lordship. And if lordship see the impugn order at page 34 lordship, the serial number 4
It's
lordship.
okay, you may say that he has already joined, but then he has already properly joined first on 2nd of April.
That is their lordship. That is their lordship. So here only the term modification that is.
So you want some time
Otherwise,
to produce the records.
lordship, day after tomorrow lordship.
Then
Inter matter can be disposed of lordship.
we'll hear the caveat. He wants to bring on record tomorrow. He wants to bring the records day after tomorrow.
Therefore, tomorrow is a holiday.
Holiday. Friday you can take it up.
Yes, my lord. But so far as, my lord, the law is concerned and so far as the records are concerned, I cannot say anything now. But there is something I'd like to point out. If your lordship will see page 34, the impugn transfer order. This is affecting not only him and me, it is also affecting serial number 3, who has now joined in my place, earlier place of posting. Now, if any interim order is passed, I cannot go back there since it's already joined there.
You will be adjusted anyway.
And serial number 4 is also affected, but he has not been made a party.
So many divisions. You will be adjusted somewhere.
Lordship, before passing any interim order, the entire matter may be taken up on Friday. Otherwise, Lordship, it will be an anomalous situation now. Because he has also joined, I have also joined, I cannot go back. He cannot go back, the other person, Lordship, the serial number 3. Even the serial number 4 is affected, but he has not been made a party also. If your Lordship sees, serial number 3 was posted in the place of serial number 4.
You have joined, according to you.
Yes, I have also joined, and the person at serial number 3.
When?
Lordship, this is on 20.
20.
Yes. And
You were transferred where?
Lordship,
Bandar Dewar to Sangali.
Sagali.
Sagali.
Okay.
I was at Sagali. I was transferred to Likabali. Then the serial number 3 was posted in Sagali in my place. The person at serial number 3 has joined in Sagali. Now, if any order is
By this 1310 order, you were posted at Sagali. Sagali.
Yes, Lordship. I had joined there in Sagali. Thereafter, this order came.
Again, you rushed to Likabali.
Not rush, Lordship. Because I have only followed the orders, Lordship.
Follow the order, or you have asked for it.
No, Lordship. That would be jumping the gun. I'm sorry.
Ask for it, followed it.
Now, Lordship, we'll see page 34.
We'll take it up tomorrow. You produce the record. What's there? What's big deal?
Tomorrow, Lordship, on 29, Lordship.
No, 29 will be the. Then we'll not be able to dispose of the matter.
Friday, Lordship, it's more metal, Lordship. Basing on the record, Lordship can.
Senior lawyer is there. She is there. We'll have to hear everyone. Is that it, madam? We'll take it up tomorrow. You produce the record or whatever you. Not necessary for disposal. We'll hear you tomorrow and pass the order. Is that it?
Because they have to bring on record.
It's up to them.
Filing affidavit.
Tomorrow.
I'll try because it's only 2:30, Lordship.
Or Friday. It's a transfer matter. What's there? Friday? No, not now. Without hearing. No, in that case, we'll issue notice and pass the interim order. That's what's there. See, you want to bring on some record. You're alleging malafide. They are saying that it's a public interest, normal transfer. There's no bar as such. Friday. As agreed to by the Land Council for the parties. No, you just heard Mr. PJ Soike, Land Senior Counsel, assisted by Mr. T. Taba, Land Counsel for the petition.
I can bring this on record, and we may try to, otherwise, we should be a part of record only. Because these are supplied to me.
What is that? What is that? What malafide?
The transfer is mooted at the behest of the local MLA.
Who said?
It's the letter of the local MLA Deputy Speaker himself. Along with the various.
Then they will bring Mohammed Masood.
No, that's one thing. But here ground is that he is a local resident of Likabali.
So what's wrong?
So that is
He's a local this MLA.
I am at the verge of the retirement. My residence is that permanent residence is that Pasar. Hardly 1.5 years to go. I have been my post settlement everything. Post retirement settlement recovery has been given. It is about 70 to 80 kilometers.
It's okay. The challenge made in this writ petition is to the order dated 18/05/2026, passed by the Chief Conservator of Forest within bracket headquarter, HQ, bracket close, Department of Environment, Forest and Climate Change, Government of Arunachal Pradesh, whereby four officers, including the petitioner, have been, including the petitioner and the respondent number 6, have been transferred from transfers to various places of posting as DFO by modifying the order dated 13/10/2025 transferring the petitioner from from where?
I have been transferred
From the DFO
Namsai.
Lohit to DFO Likabali.
To DFO Lohit.
List of the respondent number 6
From Sagali.
who was transferred from Likabali to Likabali to Sagali earlier.
Earlier, Lordship, Bandardewa to Sagali.
Bandardewa to Sagali, as DFO has been is sought to be transferred in place of as DFO at Likabali in place of the petitioner. Next para. The having considered the nature of the case being transferred and posting, learned senior counsel, learned senior government advocate Mr. Estepin is directed to produce the records, as the learned senior counsel has alleges malafide in transferring the writ petitioner list of MS. The learned counsel for the petitioner as well as MS Endang and learned counsel for the caveator with it bracket respondent number 6 may also file appropriate affidavits if so advised. As agreed to by the parties, this matter on 29. If possible, we'll dispose it of.
Close.
If not, we'll consider the interim prayer.
Close.
All right. Then you have already joined, we'll say. Needless to observe that till 29, the status quo as on today shall be maintained.
But he has not given charge. It is the issue.
It's okay. It's a matter of 2 days. It
Yes.
does not make it more complicated.
Yes.
We'll see. We'll see on 29.
No, it will create a very anomalous
No,
situation.
we have
Not just me, the other parties
the
also.
experience. The status quo is sometimes it's counterproductive. Rather than they providing justice.
The respondent 7 also will be affected. He's already joined in Sagali.
We'll see.
Obligement.
To that extent, an observation that this cannot be disposed of when the interim prayer will be considered.
Obviously, we'll hear you. It's a
Item number 5.
Yes.
One rocket. That informed me that we will not able to appear before the court.
Union.
When?
29.
29. As prayed for by Mr. G. Gautam Land, counsel for the petitioner, that this matter be listed on 29.
Much obliged.
Otherwise, it's a covered case.
Yes.
Covered case.
Yes.
Are you sure?
Sure.
What's here? In that case, you could have.
Cancellation of GST certificate.
If it's covered case, you could have disposed of. Anyway,
Tribunal order passed.
it's okay. Since you have asked, you have prayed for 29. It's all right.
Item number 8.
In process. In process.
This matter, yes, in fact, it has become in process.
That is what he is submitting since other
friends.
No, no. Listen, may I take you to the provision of section 64? Who shall make an application for a reference? Section 64.
Anyway, why you are saying it's in process?
My lord, for reference, their complaint has been forwarded. The compensation amount has been deposited to the authority, which is the
Reference has been.
The complaint has been forwarded.
Reference has been made to the district judge.
Yes.
Then
It is the collector who will send send for reference to the district judge.
Reference has been given.
You have filed, all your complaints have been forwarded, the money has been deposited, the compensation
They
amount
have
has been.
treated the complaint as a reference.
Yes. If if he seeks liberty that he may file a proper reference also, proper complaint, that also can.
Your money has been deposited in the district court.
Yes, my lord.
Regarding
You obtain instruction.
Lordship, regarding deposition of this compensation amount, they have filed additional affidavit on 30/3/2026, saying that amount has been already filed in the court. But
Yes.
we have filed RTA application. The reply was furnished on 8 April, saying that the amount has not been filed.
Currently underway. However, the process of parking the compensation amount is currently underway and we are making effort to complete it at the earliest. They already sent.
But till then, Lordship, on 9/4, this honorable court has passed an order saying that no adverse action, no any actions against the petitioner has to be paid.
My lord, already land has been handed over to the railways. And my lord, the entire writ petition is on the ground that earlier an assessment was done and subsequent assessment has not been done. But the compensation amount has been reduced by deducting the components. My lord, specific advertisements have been made. My lord will kindly see.
No, wait. You have filed the affidavit. On what basis you are saying that it has become in process? Let us see your affidavit.
My lord, in the additional, we have filed another additional affidavit.
Additional affidavit.
Yes.
When?
Additional affidavit filed on 11/5/2026.
Yes.
My lord will kindly see page 110. Annexure 8, 110. This is to the presiding officer.
110.
Yes. Deposition of compensation amount in case of NF railway line and overbridge so and so so and so. This is to inform that the office of the district
Have you
land and
responded to this
No, sir.
additional affidavit?
No, no, sir.
Then you file, if you want to respond, we'll grant you time. Is not it?
yes, my lord.
Because he's disputing that it is not.
No, his dispute also, my lord will kindly say it has not been parked. What he's saying, it is in the process. In the process of completion. My lord, the writ petition itself is on the ground that second assessment has been done without re-verification and certain components have been deducted and thereby their compensation amount has been reduced. Their complaint also is that components have been deducted earlier as per the earlier assessment. The components in the second assessment, the components have been deducted without any re-verification and thereby causing the compensation amount to be reduced. That is the ground. Then I'll
page 111. In pursuance of so-and-so and transparency, the matter is referred to the authority for their consideration. In view of the project being in so-and-so, may accept the deposition of the award in view of so-and-so. In pursuance of section 71 of the law, Nation is now liable to hand over the record land to the. Where you have said that money has been deposited?
First affidavit, additional.
No. My lord, my lord, the
Proposition of compensation amount
Yes.
is 112.
other than
Therefore, in view of this project being of the assets total compensation yet to be disbursed to the remaining 8. You are 8. You are 8%.
Lordship.
6% there.
Presently 6%, Lordship.
Is rupees 1 crore so and so. This is the second assessment. 1 crore 63 is second.
Yes, yes.
Yes.
Earlier, how much?
Earlier, initially, government sanctioned for the 9 crore, Lordship. But it was reduced to 6 crore.
Then
Lordship,
then 1 crore.
yes.
No, the rest had been disbursed. The rest had been accepted by the other beneficiaries.
Compensation rupees 4 crore 92 so and so.
1 crore, yes. This 1 crore 63 is for the remaining 8 landowners who are agitating the compensation amount.
You pursue before the authority.
Lordship, here, Lordship,
Then thereafter also, it's not that your doors are shut. Let them determine.
My lord, I'll just, if my lord,
Give you a liberty to file appropriate application.
that should be, my lord.
Claiming you, whatever you claims, press application before the authority.
Lordship,
My lord,
Because ultimately, we cannot just decide.
yes, exactly.
Lordship, in my
The acquisition was under the 2013 Act.
yes, Lordship. Lordship, my contention before your Lordship is, Lordship, since they have assessed and prepared the compensation amount, but that on 2 occasions, but on that 2 occasions, they never visited the site and assessment was not carried
So
out.
that also can be considered by the authority. District judge can consider that also.
Under reference, Lordship, reference if the acquisition process has been carried out as per the act, but if there is a certain
Suppose if they visit,
dispute,
if they visit it and found the same amount, what will happen?
Lordship,
Suppose if they visit the site
yes, Lordship.
and come to the conclusion the amount remains the same, then
Lordship, it will not be possible because if our grievances is at least they have to be
now
site.
the land has already been handed over to the railways again.
Yes, my lord.
And
it's a construction of railway.
Lordship, our portion is, Lordship, not for land has been acquired for the railway purpose, but
The others have
in the construction.
others have accepted. Why you are agitating?
Other land is at the Lordship construction.
Their this thing has been not been reduced. Their claim has not been reduced.
No, Lordship.
Only yours.
Only including this 8, Lordship.
No. Everyone's compensation was reduced. My lord, I'll just take your lordship to the entire case. My lord, only 2 paragraphs, page 23. What
Let
this
us do
case
one
is-
thing. Let us do one thing. Since you are basing on your additional affidavit, let them file a response. All right, then we'll consider.
My lord, then,
Otherwise, if he agrees, I'm also prime view that he should agitate before the authority.
yes, my lord.
But he said,
My lord, that in that event, my lord may kindly also reflect that this since we have already handed over the land to the railway authorities, my lord, on 12 itself, and construction, they should not.
when did you hand over it?
12th of March itself. After reference was.
They're disturbing or what?
No, that we apprehend. Otherwise, just because of the pendency of this case and then an observation that no action should be taken, that would prejudice their rights. That observation, taking advantage of that interim order, they might disturb. That is the apprehension. Because after all, construction, my lord, is being carried out.
The construction part is, Lordship, at the station and the railways only. But our side is a land which was acquired additionally for an entrance part. Lordship. There is no any construction in our land.
Have you mentioned it in the writ petition?
Lordship.
That the land has been handed over to the railway?
No, at the time of filing of this writ petition, Lordship, it was not handed over. Only notice was issued saying that within 7 days, if you fail to receive the amount, then then will be handed over. That notice I have enclosed in my room.
There is 12 March. You have filed the writ petition on 18, maybe 17.
Writ petition was filed on both sides. 11th March.
Interim was,
Interim was granted on 9/4.
yes.
But the granting of interim amount was not deposited. It was under process as per our here reply also.
You obtain instruction, we'll take it up on 29. We'll have to see the public interest also.
Yes, sir.
When you have not been, left remediless,
Yes.
they have referred the matter to district court.
My lord, if my lord give,
Let us see, you obtain instruction.
my lord, if
We'll take it
my
up
lord,
on
that
29.
also would not require, no any further instruction would be required. If
Not
my
to
lord,
you.
yes, my lord. If my lord kindly see page
Instruction, it
23.
says from his, the
Yes.
petitioners only.
Page 23, their entire case is that in the second assessment, certain components have been deducted. That's why the compensation amount has been reduced. Now also from their own writ petition, the first compensation and the second compensation, whether any
Will not accept the job of the
exactly
authority.
no components, the components are the same.
District judge will do that.
Yes, the components are the same, the number of plants, trees, whatever the properties are the same.
That's why
Only the rates have been reduced.
Precisely asking him, requesting him to take instruction.
Yes,
Prime
only the rates have been reduced.
You should agitate there.
It is,
Thereafter, you may come back.
they are only seeking re-verification. The entire case has been built that there was no re-verification and components have been deducted.
Yes, Lord.
No components also.
Amount was also reduced, Lord. There was
The rates of the components have been reduced.
Okay.
The components have not been reduced.
Okay, heard Mr. K. Lawlett, Learned Counsel for the petitioners, as well.
Components have not been reduced, nothing for re-verification.
Additional Advocate General for the state respondents.
Appearing on behalf of Nkapa corresponding number
Your name, please.
O. Jerango.
Oh, Gerard, Learned Counsel for appearing for censure.
It's not
He's a very important man. Why is not appearing? Railway project. Let this matter be listed again on 29th. No, before you said, considering the issue involved, which pertains to construction of railway line
Yes.
and the compensation for the land which the affidavit and considering that the affidavit, additional affidavit filed by the state respondents reflects that the matter has been referred to the district judge Pasigat.
Yes.
District judge Pasigat referred to the
Isyam.
Referred to the Pasigat and also Isyam Pasigat in terms of the provision of right to fair compensation, so and so, 2013, along with the and the amount, along with the deposit of the amount before the authority. Come on. Let this method be listed on 29, 05, 2026. 29 or what?
My lord, Let it be then next week, my lord.
When?
4th.
04/06/2026. So as to enable the parties to obtain instruction,
I'll file rejoinder.
particularly to you.
Yes, I'll file my rejoinder.
Okay, it's up to you.
My lord, since land has already been handed over, the petitioners shall not disturb in the construction.
Yes, Lordship, but Lordship,
That-
order 9 for that may be considered.
Let the interim order continue. Let the interim order 9/4 be continued.
Only continue. That's why I wanted to fix it on 29.
My lord, with the order, the petitioners shall not disturb in the construction.
That we cannot know at this stage. You file an appropriate application, we'll vacate that.
My lord,
Modify it.
otherwise,
They are disturbing or what?
no, my lord, we apprehend because the
See,
construction.
considering all this, I wanted to fix the matter on 29.
29 Friday, my lord, that's why.
So you file an appropriate application for that.
My lord, then on 29, my lord.
4th.
29, my lord.
29, Lordship. I'll file my rejoinder.
29.
Try till 29, Lordship.
29 for disposal, my lord, then.
29 may not be possible in that case, unless he withdraws.
Yes, my lord.
Unless he withdraws.
If we had already filed this additional affidavit long time back, now still.
4th.
4th, my lord may only observe that since it's a public interest project, petitioners shall not disturb in the construction.
Don't disturb. Will you disturb?
No, Lordship.
Then?
Yes, my lord.
That interim order may be considered.
Interim order earlier part shall continue. However, learned counsel for the petition assures that no disturbance will be created to the authorities. Undertakes that the petitioner shall not create any disturbance to the
In the construction, my lord. In the
to the authorities.
Obliged, my lord.
Item number 11.
Steps, unserved notice, not found in given address. Further service in response number 2 and 4 are still awaited. Office note dated 25/05/2026 indicates that unserved notice in respect of response number 3 has been received back. And the service report in respect of response number 2 and 4 are still awaited. List of considerable. While awaiting service report in respect of response number 2 and 4, Learned Council MST to take press steps for service of notice upon response number 3 within 2 days. MSK T. Wangmo, Learned State Council is present. You have filed an affidavit. You don't want.
No, madam.
Not required. You want?
Yes, madam, we'll file, madam.
Okay. List the matter after 3 weeks. In the meantime, State Learned the MS Wangmo Learned State Council may file the counter affidavit.
Item number 14.
Yes.
Maybe, the state service from responding about 4 practices.
What about 3?
3 is present.
I will appear for 3.
Response 6 are still awaited. Huh?
I will appear for respondent 3.
Okay.
I have not filed the wakalat number, but.
Anyway, Mr. Newbury Learned Council, enters appearance on behalf of respondent number 3, Mr. As prayed for by Mr. Odugong, learned counsel for the petitioner. 3 days time is granted to take precise steps for service of notice upon respondent number 4 to 6, 4, 5, 6. 4, 5, and 6 by Dusty Mott. List the matter after 4 weeks in the meantime. And you just record.
On correspondent number 1.
I'm for 2.
Are present. In the meantime, thereafter, are present, then you write list the matter up to 3 weeks. In the meantime, respondents may file their respective affidavit, counter affidavits.
Okay. Unlisted item number 16 and 17.
Liberty, no liberty.
No liberty, madam.
Mr. M. Doji, learned counsel for the petitioner, submits that he has an instruction to withdraw this petition. Therefore, prays for withdrawal of the same. Next para. Who else are appearing? Union of India.
Yes.
You are also there.
Nearest here, Lordship.
On behalf of Mr.
MS N. Anju, learned counsel. For respondent number? Respondent number nearest is present. Accordingly, the writ petition stands closed on withdrawal. Same order in item 17. You come. Hello.